What happens to a bank account when someone dies without a beneficiary? Hello, I'm attorney Thomas Burton, and that's today's question. So many people know you can designate a beneficiary on your bank account, similar to designating a beneficiary on an investment account or retirement account. In Wisconsin, this is called a payable on death account, payable on death beneficiary designation. And it's actually in the Wisconsin statutes that you can do this on your bank account. And I recommend doing this to avoid probate on the bank accounts unless you have those accounts held in a trust. That's my preferred method. Have all your accounts flow through your revocable living trust to avoid probate upon death. But let's say you don't have a trust, or you have one account over here, you can make that account payable on death to your heirs, or just have it pay on death into your trust to be distributed privately according to the terms of your trust after death. So that's great to have payable on death designated. But what happens if you don't have someone designated? Well, the default is if there's no payable on death beneficiaries on your account, the bank would freeze the account as soon as they learn of your death, and then they would wait for further instructions, generally from the probate court. So most of the time, the bank will tell you you need to go open a probate court action, get appointed as personal representative, and then you would gain access to the funds, because the funds technically become part of the deceased person's estate. And if they had a will, the last will and testament will govern what happens to the estate. And if they didn't have a will at all, then they're what we call died intestate, and the estate will get distributed according to the Wisconsin laws on intestacy, generally to the closest living relatives. And you need to trace that through the statutes depending on your family situation, where you married, single, did you have children, a blended family, things like that. So the default is the funds belong to the estate, and they are frozen after the deceased person's death. So sometimes I see people who want to spend funds after someone dies. You shouldn't be doing that, because any authority you had to spend funds, for example, let's say you were the power of attorney under a financial power of attorney. Sometimes I see people think they can spend the funds after the person dies. You can't, because that authority terminates when they die. So unless you're a joint owner on the account, when someone passes, that account has to either get distributed to the estate, or if there was a payable on death beneficiary designation, that would dictate what happens to the assets. So I think it's a great idea to fill out these beneficiary designations. Just make sure, if you do, that they coordinate with your entire estate plan, because be aware that whatever you have on file would override your will or trust. So that's why I mentioned earlier, if you have a trust, it makes sense to me to have everything dump into the trust and then get distributed according to your instructions there as a private administration after your death. Now, be aware, in Wisconsin, the small estate limit is $50,000. That means if you leave any assets subject to probate in excess of $50,000, you must go through a probate court action. If you're below that limit, there is a simplified transfer by affidavit method that can be used for a bank account. I have used it, for instance, one bank account with $3,000 left in it. But be aware, it's still complicated, and the banks don't like to deal with them. In my experience, they would prefer to tell you to go open a probate court action and spend several thousand on fees and attorney fees than to deal with it. So even if you can do the transfer by affidavit, it's often a lot of work, and some people end up hiring me to help because it's a lot to figure out on their own. And I'm sympathetic and I help them, but it still takes me time, because the bank often doesn't want to cooperate, and then the costs are still there. So it isn't like it's just simple and easy and no cost. So the simple, easy, no cost is to fill out the transfer on death, payable on death beneficiary designation before you die. If you do none of that, no planning ahead of time, everything unfortunately gets complicated and is going to cost time and money. So the choice, of course, is up to you, but the reason I make these videos is to help educate and inform others. and I give you real feedback about how I see things play out in the real world. And hopefully this is helpful to you as you consider your own assets and estate planning. So thanks for asking this wonderful question. Thank you for tuning in, and we'll see you next time.